Counsel for Appellant in the case of G.E. et al. Versus Department of Children and Families. You may proceed.
May it please the Court. My name is Mary Kay Brennan. I'm an attorney with Jacksonville Area Legal Aid. We and the law firm of Mills and Carlin represent the appellant child G.E. We're here today to ask this Court to reverse the trial court's order committing G.E. to an inpatient mental health facility. This case is a case of first impression under Juvenile Rule 8.350, and it involves the admission of the report of the qualified evaluator into evidence without the testimony of the evaluator. It's our position that that constituted an abuse of discretion, did not constitute...
Doesn't the rule say that that report shall be considered?
It does, Your Honor, but our position is that it doesn't mean that the rules of evidence don't apply. The rule preceding that one, in fact, 8.340, does exclude certain types of evidence from the rules of evidence. There's no such exclusion, especially in this rule. The statutory criteria that the Court has to be satisfied with are set forth in Chapter 39.4075. Those statutory requirements set forth specific things that the qualified evaluator must be. For example, that qualified evaluator must be either a psychiatrist or a psychologist with at least 3 years minimum treating serious emotional disturbance in children and adolescents. We have no idea in this case whether or not that report was never authenticated. We don't know whether or not under the statutes the qualified evaluator had any conflicts with any of the inpatient facilities, again, part of the statute. And the crux of the case, the evidence that the state had to show is set forth in that statute regarding the qualified evaluator's findings.
Well, are you raising a question about the evaluator's qualifications?
Well, I'm just pointing out, Your Honor, that we never had an opportunity to question the evaluator either about her findings or about her own personal observations or about whether or not she actually did the evaluation herself. They never presented the person for examination.
But I mean, as far as those meeting the statutory criteria, is she a psychiatrist?
It's my understanding that she signs her name a PhD, which would lead me to conclude that she was a psychologist. But the statute does require that those findings be made by someone who's qualified either as a psychiatrist or as a psychologist. So the statutory requirement that the child be, that in that person's opinion, in that person's professional opinion, the child have a serious emotional disturbance, require inpatient or residential treatment, and the child would benefit from it. The fact, those are the statutory criteria. The fact that the state attempted to meet its burden through a hearsay report, which itself contained hearsay, we say was an abuse of discretion on the part of the trial court.
Well, there were several other witnesses, right, all of whom agreed that residential placement was appropriate.
That's true, Your Honor, but they could have paraded 100 people in. If they're not a qualified evaluator, they haven't met the statutory test under 39.407.
Was there an objection made to their qualifications?
No, Your Honor, there wasn't. They were not offered as expert witnesses. And nor did we preserve the objection that it deprived the child of his right to confront.
The purpose of their testimony was clearly designed, was it not, to offer an opinion as to whether the child required residential treatment care, was it not?
Yes, it did, Your Honor. However, those persons were not qualified to meet the statutory standard. As in the Baker Act, the statutory standard requires a psychiatrist.
Then I come back to my initial question, which you've already answered, that you said they were not qualified, but no timely objection was made to their testimony as experts.
Your Honor, we're going to whether or not the evidence through the hearsay report met the statutory standard. We say it was an abuse of discretion to allow the report to stand without offering the child an opportunity to confront and by including in the report itself prejudicial hearsay information.
Does it appear that any of the persons who actually testified relied upon the report in forming their opinions?
I don't know, Your Honor.
Well, as you're aware, an expert can rely upon evidence which would not otherwise be admissible in evidence.
That's true, Your Honor, and we don't question that that's true. The problem here is that the expert, Dr. Vail, did not put forth just her own opinions in the report. She basically was a conduit for other people's information, which would be objectionable hearsay. In this particular instance, we did not preserve our challenge to the report on the grounds of the child's right to confront. But this is fundamental error to deprive the child of his right to confront the primary evidence.
How many witnesses, in fact, testified that the child required residential treatment?
I think that every one of the witnesses said that if the first two, I believe, said that who had not seen the child for approximately a year, said that if the child could not make it in a therapeutic foster home, that residential treatment would be appropriate. The other three, I believe, all said that they felt, and in fact they did, they went to the multidisciplinary committee and skipped the authority to put the child in a therapeutic foster home and asked, rather than put the child in a therapeutic foster home, to put him in an inpatient residential facility.
No, at some point he was in if briefly, was in a therapeutic foster home, right?
That's correct, Your Honor. He was, I believe, from August through the end of December. And I believe that Ms. Jalla testified that, in her opinion, the parents undermined that placement. And that she said that, I believe she testified that even though they knew that the parents were undermining the placement, they'd have to go to court to change the visitation with the parents to preserve the placement, and they did not do that.
Now, yes, you have indicated that we do not have to decide any question concerning any right to confrontation. But
no,
of course, that traditionally is understood to be the right of the criminally accused.
I don't think I said that, Your Honor, and if I did, I did not mean to. What I said was that we did not preserve that objection at trial. However, because it's fundamental error and it goes to the heart of the case, goes to the very merits of this case, we are allowed to raise it for the first time on appeal.
But the right of confrontation is a right of the criminally accused, right, and not the right of a child in these circumstances.
Well, this is a mental health commitment, Your Honor, and there's ample case law that suggests that the libertarian interest, the child's liberty interest, is so substantial that, like the Sixth Amendment in criminal cases, that due process protections do attach. And we have in Ray Beverly and a long list of Florida cases that support that finding.
Due process, but as distinct from a Sixth Amendment confrontation, right?
Well, due process, as Kelly v. Goldberg describes, the very essence of it is the right to defend, and that includes the right to confront any adverse witnesses against you. And that case...
Well, you did object on hearsay grounds.
Yes, we did, Your Honor.
And so I gather it's the Second District has spoken, but we have not on the standard of proof, the burden that the state has in these circumstances. And you're advocating a clear and convincing standard.
Yes, Your Honor, similar to J.W. in the Second District, yes.
And so you're saying this report wasn't even evidence. So how could it amount to clear and convincing evidence?
That's correct, Your Honor.
But then Judge Irvin's been asking about these numerous other witnesses, all of whom you're telling us thought that residential placement was a good idea.
Well, by analogy, if I may, in Rivera, the clerk came in to present the lab report on whether or not the substance that the accused was supposed to have had was cocaine. And the court in that case said, no, that's hearsay, and you have to bring in the person who actually conducted the test. That's essentially our position. You can have all kinds of people come in and say, well, we think it was cocaine, but the person who's charged by the statute of making that determination never came into court, and the child never had an opportunity to confront that witness. That is the very crux of the state's case, the qualified examiner's report, qualified examiner's opinion, whether or not the child suffers from an emotional disturbance serious enough to require inpatient commitment, whether or not the child will benefit from inpatient commitment.
All right, now, which criterion do you think the report was necessary that only the report could establish, or only the author of the report?
Well, the statute's pretty clear that the diagnosis of serious emotional disturbance is something that is preserved for psychiatrists and psychologists, and I believe we cited that statute in our brief. The statute says that the qualified examiner must either be a psychiatrist or a psychologist licensed who's had at least 3 years' experience treating serious emotional disturbance in children and adolescents. And none of the other witnesses qualify as a qualified evaluator.
What about Sarita Mullen?
Sarita Mullen was a social worker, and she hadn't seen the child since she did a comprehensive assessment in July, I believe, of 2004.
All right, now, Tanya Bush had a degree in psychology.
No, she had an undergraduate. She majored in psychology, I believe, in college.
Okay, well, you say, all right, so what are the statutes that requires that the evaluator who does the report be either a psychiatrist or a PhD psychologist?
Correct, Your Honor. And be licensed.
Were any of the other witnesses licensed in any way?
Actually, no, Your Honor.
So partly your objection is that, that objection was stated clearly, that the report is hearsay and the author is not here for us to cross-examine. But did you argue at the hearing that no commitment was possible because no qualified evaluator was called to testify?
I'm not 100% sure what the question is, Your Honor. We did not say that the court couldn't find the child to be not to meet the statutory standard because they didn't testify. We objected that the report was hearsay and that there was hearsay within the report.
All right, but you didn't say to the judge, well, you can't find this child severely emotionally disabled or whatever the language is because no psychologist and nor any psychiatrist has testified.
No, I probably did not, Your Honor. However, the child did not have a right to confront the adverse witness against him, who was Dr. Vail. And although we didn't preserve that constitutional right to confront, we were allowed to raise it for the first time here on appeal. If we construe the rule...
what is your authority for that?
I'm sorry, for raising it on first time appeal?
Right, I think there are several criminal cases where it comes up in this, what with the Crawford v. Washington situation, where people have made a hearsay objection but have not specifically objected on confrontation grounds. And I think that in the criminal context, it has been said that the objection is waived.
Well, for authority, we cite Hooters and the Department of Insurance versus Keys Abstract Company. But in terms, are you talking about the Menkos case, Your Honor?
I'm talking about a slew of criminal cases where we have said if you don't object specifically on those grounds, the objection is waived, and we have not treated it as fundamental error.
Well, Your Honor, we cite Hooters and Department of Insurance versus Keys.
Well, now the second case certainly has nothing to do with this, does it?
I'm sorry?
The Department of Insurance case, what does that have to do with this case?
Well, it's Your Honor's, it's precedent that says that when you're talking about fundamental error, you don't have to raise the objection. You have not lost it. You can raise it for the first time on appeal, which we're doing here. In addition, there are other cases, Williams, State v. Sanford v. Rubin, Johnson, State v. Johnson are two others, Your Honor. KV versus the State that say it's fundamental error and may be raised for the first time on appeal.
So you could just sit through a trial, never even state a hearsay objection, and then on appeal argue that some of the information on which the fact finder relied was information reported by a witness.
Well, I believe in Hooters that was exactly the case, that they did not raise any objection because it was a default judgment.
What were the facts in Hooters?
Well, as I understood it, they did not raise any objection because they did not defend the case. And they tried to...
Well, what was the issue?
The issue was contract for purchase, option to purchase. I believe Carolina Wings had an option to purchase or participate in new restaurants, new Hooters restaurants.
Well, the question there was about under what circumstances may a default be set aside.
I'm sorry, Your Honor.
The question in that case was, under what circumstances may a default be set aside?
Well, we would argue, Your Honor, and we'd also like to save 3 minutes for rebuttal, if we might, that this is a constitutional, that to interpret the rule, the new rule, 8.35, as to allow hearsay objections on the most critical element of the case would be to render it unconstitutional.
Thank you.
May it please the Court. My name is Donna Thames. I'm the attorney for the Department of Children and Families, the appellee in this case.
Let me ask you this. Do I understand correctly that there is no authority under the statute, Chapter 39 or elsewhere, for the allowance of this report into evidence?
That's correct, Your Honor. I mean, the only thing that makes mention of the report is the rule. But that's actually not totally correct. The rule states that the written report of the qualified evaluator is a factor for the judge to consider at the trial level. The statute 39407 was not amended when the rule was amended, and so the report was to be filed with the court without a hearing. So the court would have seen the report without a hearing.
Well, I believe that the Administrative Procedure Act does say that if the critical fact of determination is based solely on hearsay, then, of course, that would constitute reversible error, would it not?
Your Honor, the Department's position would be that based on the statute and the rule, that the written report is permissible and it's an exception to the hearsay.
Based on the rule?
Based on the rule and the statute.
What statute?
39407.
Okay, now I just asked you that question, and I thought you...
You're right, and I incorrectly answered that, because 39407 was not amended after the Rule 8.350, and with 39407, it did permit the introduction of the written qualified evaluator's report because there was no hearing. Basically, the child would be committed, and then the report would be filed with the court.
How can you say that the statute allows the report in evidence at a hearing if it does not contemplate a hearing?
It did not address the hearing issue. With the amendment to the rules addressed the fact that we would have pre-commitment hearings prior to committing the child. So the rule was not amended to reflect that change. Or, excuse me, the statute was not amended to reflect that change.
So the correct answer is the first one you gave, Judge Irvin.
Correct.
No statute provides this report shall come in evidence.
Right, because it didn't envision a hearing when the statute was written.
This is a sad situation, isn't it? This is an 8-year-old, now 9-year-old child whose stepfather, among other things, cut all his eyelashes off.
That is something that Ms. Brennan asserted, yes.
That's not the case.
I'm not factually sure if that is the case or not, Your Honor. That was contained in the comprehensive evaluation. I'm not sure where the information came from, whether it came from the interview with the child. That was not a material element in our dependency case. It is
we're beyond dependency,
right? That's correct.
The dependency determination is not an issue now.
Correct.
The question is whether this child should be placed in a foster home or in a mental institution.
Well, he's currently placed in a residential treatment facility, which, I mean, you're classifying it as a mental institution, but it's a residential treatment facility for him to receive help with his problems that he has. And eventually we're hoping that he would be stepped down to a therapeutic group home or a therapeutic foster home. The child will be 10 in July.
All right, so the only recommendation or report or opinion from a licensed psychologist or psychiatrist is this report that came in over hearsay objection.
Yes, Your Honor, correct. Although there were 6 other witnesses with various degrees of levels in social work and psychology degrees, she was the only licensed psychologist. The department strictly followed...
Would you agree with the contention that if this were a Baker Act hearing and if there were 6 other witnesses, but the psychiatrist who couldn't make it and a report was offered that a hearsay objection should be sustained and the proof would fail?
Your Honor, I would somewhat agree. I'm not that familiar with Baker Act. I'm under the impression that the Baker Act does not apply to these cases based on the M.W. versus Davis case. I understand in Baker Act you are appointing a public defender and the process is slightly different. So yes, I would imagine they would rule it as improper hearsay. However, in this case, because we have a specific rule which tells us what evidence we have to introduce on a hearing on placement, that is the reason that the written qualified evaluator's report was filed with the court. Ms. Brennan did not raise the objection to her qualifications. Actually, a qualified evaluator is a term of art. They're appointed by the Agency for Healthcare Administration. It's a specific appointment, and she's really a gatekeeper for Medicaid funding. So her opinion is just one of many that should be considered in having the child committed to a residential treatment facility.
Counsel, the department concedes that this report is hearsay. Is that correct?
Correct.
Okay. And you have alluded to the rules as a basis for admission of the report. Looking at the evidence code, specifically section 90.802, specifically provides that hearsay is inadmissible except as provided by statute.
Correct.
Is that correct? Now, would you agree that the wording of the statute is clear?
Correct.
Okay. This court and the Supreme Court has previously held that when the language of the statute is clear and unambiguous and conveys a clear and definite meaning, there is no occasion for resorting to the rules of statutory interpretation and construction. The statute must be given its plain and obvious meaning. With that said, are we allowed to even look at the rules if the statute is clear and definite?
Yes, Your Honor, but my argument to that would be that statute 39407 permits the written evaluation to be given to the court. That's the procedure that was done prior to the rule being revised. Let
me ask you this. What is your position on what the standard of proof is, the burden of proof for the department?
Your Honor, I believe our case proved the case by clear and convincing evidence. I understand there is a second district court opinion on it, and there's a proposed, I think, rule change, and we would, the cases that I present to the court, I would try to prove by clear and convincing evidence.
All right. But now, so if the burden is clear and convincing evidence, and if the report is hearsay, how is it that the report can prove the case?
Your Honor, the report was not the sole thing that proved the case. We had 6 other witnesses, the Mental Health Resource Center records, which showed the numerous Baker Act admissions. We also, we had the 6 witnesses that overwhelmingly testified that they recommended residential treatment facilities. The witnesses were his therapist, his caseworker, who was a supervisor at the time of the case went to trial. And she and the guardian ad litem all concurred that residential treatment would be the appropriate facility for this child. The child presented no witnesses on his behalf, and he made no argument that that would not be an appropriate placement for him.
So you disagree with the proposition that a psychiatrist or psychologist has to testify at these hearings?
Correct. The rule does not say that they have to. The only thing that is required is the written qualified evaluator's report, the recommendation by the department's representative, the recommendation by the guardian ad litem.
Does the report have to be prepared by a psychiatrist or licensed psychologist?
Yes, Your Honor. It has to be prepared by a qualified evaluator, which is someone who is appointed by the Agency for Healthcare Administration.
All right. Now, did the department establish that this report was prepared by such a person?
Your Honor, that was not an objection. The report is signed by the psychologist, and she asserts under her signature she's a qualified evaluator.
Counsel, getting back to my question, where in Chapter 39 does the legislature specifically provide for an exception to the hearsay rules for admission of the report?
Your Honor, it does not, except it provides that the written suitability assessment would be provided to the court. It doesn't, there was no hearing, so if the written findings...
Chapter 39 does not specifically provide an exception for admission of the report and evidence.
Right, but it provides that the written findings of the evaluation would be provided to the court. There would be no hearing, there was no hearing contemplated when I'm sure there were some types of hearings, but the child usually was admitted and then the report was filed with the court. I think that there are adequate protections this child has because he had the right to a hearing, he had the right to counsel, he had a guardian ad litem appointed, he had the opportunity to be present at the hearing. I think those were all the issues that MW versus Davis were concerned with, that they wanted to give the child a fair opportunity for a hearing to assert his position, and he had that in this case. He had ample opportunity before he was committed. The hearing was several hours long, and there was no, I don't believe any of the evidence indicated that he should be placed in any kind of less restrictive setting than a residential treatment facility at this time. We had tried therapeutic foster care. Unfortunately, his grandmother had wanted custody of him, and so the child went to live with his grandmother for a brief period of time. But in all likelihood, he would have, the therapeutic foster home was not, he was Baker Acted twice from that home, so that he probably would have been stepped up to a higher level of care at that point had he not gone to reside with his grandmother. The department...
Assuming the admission of the report was error by the trial court, why is it not fundamental error?
Well, in this case, there were ample witnesses that testified that that would be the appropriate placement for the child. The comprehensive assessment, Sarita Mullins, she does have a master's in social work, and she's a licensed clinical social worker. She did make diagnosis of the child, and she Also, I believe she was the member that sat on the...
Were her diagnoses the same as those that Dr. Vale reportedly made?
I'm not sure, Your Honor. Let me... Some of the diagnosis were, one of the diagnoses she made was depression. Dr. Vale found, rule out major depression.
So there's a discrepancy
So there's some
there.
discrepancies in the diagnosis.
So which ones do you think the trial judge relied on?
I think the trial judge relied on her statements in her report from MHRC, where he was diagnosed with intermittent explosive disorder.
And whose opinion was that?
Those records were from when he was admitted to the mental health resource center, and those would have been made by a psychiatrist.
All right. So you feel like the trial judge relied on the opinion of somebody who neither testified nor prepared the report.
I don't know that Dr. Vale independently makes, the diagnosis.
Is that what you just said?
Well, that would be an incorrect statement. I don't believe the child court relied on that, but
What do you believe
Dr.
the
Vale
trial
did not
court relied
diagnose
on?
the child, Your Honor. She just stated the following diagnoses were obtained from the MDT report. And so she did not independently diagnose the child. Those diagnoses were made
All right, so
from a psychiatrist.
Not only do we not have a diagnosis from the person who prepared the report, but she's just a conduit for other hearsay.
Well, she's an expert and she's allowed to rely on opinions. In making her opinion, her ultimate opinion was that.
So your position is that there's no harm, no foul. That if she had been there as a witness, she wouldn't have been able to tell us anything useful.
Well, she would have relied basically on her report. I don't think she would have elaborated much beyond what she presented to the court in her written findings.
So you take the position that a child can be placed in one of these institutions on the say-so of somebody who has not made a diagnosis.
Well, she interviewed the child, she reviewed records, her report states the various records she reviewed. I initially stated to the court, she is appointed by the Agency for Healthcare Administration. She is really a gatekeeper for Medicaid to really approve or disapprove whether or not Medicaid will pay for the placement for the child. She's just one of many that makes the recommendations for the child to be placed there. If she had come to court and testified, she would have just reiterated her written findings. I don't think she would have elaborated any beyond that. The child, even though he's being committed to a residential treatment facility, is given the opportunity to have regular hearings on his commitment. He has 90-day review hearings set before the court every 90 days, where they review whether the commitment is still appropriate or not. So it's not like we're putting him in the facility and...
Has he had one of those already?
Yes, he has.
But you're not contending that moots this case?
No.
Just as a matter of curiosity, who testified at the review hearing?
Dr. Vale submits a 90-day review report, and I can't recall who was at his last hearing. His caseworker comes, the guardian ad litem will be present in court, the child's attorney, the child, and I think his therapist attended from the residential treatment center. And the residential treatment center has monthly reports that they are supposed to file with the court that's delineating his treatment plan and how he's progressing on that. But we've had one, our second hearing actually is scheduled for tomorrow, and we've reset it to February 8th.
So it may be that, what's the outside limit? How long could a child be kept in one of these institutions under the statutory scheme?
Well, I guess he could be kept there indefinitely, except he has 90-day reviews, and I believe Medicaid does have some policy on their maximum limitations. I believe it's 180 days is what they consider would be maximum. But there
So
are
it's basically
children,
a funding thing.
well, it is a funding thing, but there are children that have been there longer than that period. I mean, part of when we commit him, he's supposed to benefit from that commitment, so hopefully he'll benefit and be discharged to a lower level facility until he's returned to his parents.
But funding aside, you're saying there's really no reason why he couldn't be kept there until he's 18 or 21 or something.
He could be if the court
And then be Baker acted.
And then, excuse me?
And then be Baker acted.
He could be, but
So it's possible that we're talking about consigning an 8-year-old to a life in mental institutions
well,
at this hearing.
correct, but he's now 9.5. And the process is working in this case, and I think he is about to be stepped down out of the program. But, I mean, the alternative is to leave him in a facility that's not, in a foster home that's not appropriate, that cannot deal with his behaviors, where he either injures himself or he injures others.
Counsel, you alluded to, I believe, the testimony of Ms. Mullen as a ground or reason why the court's error was not fundamental. So it was error to admit the report in the evidence. Is there any reason or grounds you would
Your Honor,
as a basis for
I would
not being fundamental error?
I would assert that all of the witnesses, the cumulative effect of all the witnesses with their expertise would make the introduction of the report not fundamental, because they all independently recommended it based on their experience with a child, either through therapy. Marie Flattery was the child's behavior therapist. Even though she only had him for a very short period of time, he was at Children's Home Society. He was Baker acted. He was in the mental health facility more than he was at the Children's Home Society foster home. Kelly Williamson worked with the family when the child was in a therapeutic foster home. She recommended his placement in a residential treatment facility. His case manager recommended it, as well as the supervisor and the guardian ad litem. Thank you very much. We're requesting the order be upheld.
Your Honors, just to rebut briefly, the guardian ad litem admitted on cross-examination that she had never met the child. Ms. Williams admitted that she hadn't seen the child since at least December 2004. As I understand, counsel's argument is that the cumulative effect of all of the witnesses should make this not fundamental error. However, the crux of the case rests on the qualified evaluator and that person's personal examination and personal assessment of the need for residential treatment. And in this case, there was no testimony from that person. The report itself was hearsay. It contained objectionable hearsay. When MW and the amendment creating Rule 8.350 talks about a meaningful opportunity to be heard, we know from Jenkins, from Goldberg versus Kelly, that a meaningful opportunity to be heard, whether under the 6th Amendment or the 14th Amendment, includes an absolute right to confront adverse witnesses. This child had no such right in this case. Thank you very much.
Thank you. We stand adjourned.